Hello, everyone, and welcome to HR Options webinar series. My name is Nunzio Presta, and I'm responsible for sales operations and marketing for HR Options Canada. It is my pleasure to be your moderator for today's session. Today, we will be discussing Canadian employment with particular attention to statutory updates and HR practices for leaves of absence. Our panelists will get the webinar started by discussing significant updates on sexual harassment, police checks, genetic discrimination, e-cigarettes in the workplace, and employment standards. We'll also have an overview on discussion about the types of statutory leaves and tips for managing statutory and non-statutory leaves. At the end, we'll open it up for an extended Q&A session. Before I do my introductions, I want to review the features for our online meeting room. You'll notice several windows open on your console, including the Q&A window. All windows can be minimized, expanded, and/or moved. We welcome you to submit questions throughout the session by typing a question in the box and hitting submit. Lastly, you'll see a widget at the bottom of your screen for an evaluation of the webinar that I'll be asking you to complete at the end of the session. If you have to leave early, please take a moment to complete the survey before you close out. First, I'll introduce you to Laura Cassiani. Laura is a partner in the Labor Relations and Employment Law Group in Miller Thomson's Toronto office. Laura works with public and private sector employers in a wide range of sectors and industries. She provides strategic advice on a variety of workplace and human resources issues, including regulatory compliance, human rights matters, discipline and termination, employment standards, health and safety, workplace privacy, contracts, and accessibility. Welcome, Laura. I am looking forward to hearing what you have to say today. We also have on the panel today my colleagues Kathryn, Benson, and Stacy Glass, who are both highly experienced senior human resource consultants with HR Options. Stacy and Kathryn have both worked with a wide array of companies, and their area of expertise at HR Options includes ensuring clients are compliant with employment laws across Canada, as well as payrolling, recruiting, training, employee relations, and HR policy development. At HR Options, we provide HR consulting and payrolling services throughout the U.S. and Canada, and we have been doing this for close to 30 years. If your organization is new to employment in Canada, HR Options can provide HR support, or if you're not ready to take on the Canadian employer role, let us be your employer for your company throughout Canada, so it would be your workers on our payroll. It's always nice to have options, and that's what HR Options is all about. Today's webinar will be recorded and posted on HR Options website. Also, feel free to reach out to our panelists for more information after the webinar is over. They would love to hear from you. And with that said, I'll pass it over to Kathryn, who will begin today's broadcast with a short introduction.
Hello, everyone, and thank you for listening today. So I'm just going to give a very general overview of the topics that we'll be covering today before I pass it to Laura, who will review her specific agenda with you before she begins. So Laura is going to do a very informative overview of significant legislative updates, as well as an overview of the types of statutory leaves. And then Stacy and I will offer helpful HR tips for managing statutory and non-statutory leaves, including talking about compassionate care leaves, short-term disability, and long-term disabilities leaves. And with that, I'm going to turn it over to Laura.
Thank you, Kathryn. It's nice to be with you all this afternoon. Thanks for offering my presentation today. So I'm going to spend the time I have today to go over some significant legislative changes in Ontario with you, and I'm going to focus primarily on what's happening most recently with sexual harassment and violence. And then we'll get into a discussion on changes to police checks, which of course will be relevant for employers who regularly do these checks on employees either pre-employment or during employment. And then we'll have a discussion about what might be coming down the line in terms of changes to legislation, including with respect to genetic discrimination, smoking in the workplace, specifically with respect to e-cigarettes, which of course is a hot topic, and other changes to the Employment Standards Act that may be pending. After we review that section, I'll take a look and review the statutory leaves of absences for those employees in Ontario and in provincially regulated employers. And then I will hand over the discussion to Kathryn and Stacy to get us through managing statutory and non-statutory leaves. So the most important legislative change this year certainly has been with respect to sexual harassment and violence, and with the passing of a bill earlier this year by the Ontario government, we're going to see we are going to see very shortly they'll be in force changes to the manner in which employers are required to respond to sexual harassment and sexual violence in the workplace. Effectively, what these changes will do in the aggregate, of course, is to enhance the protections available for employees in the workplace where there is a complaint of harassment, sexual harassment. And you'll see as we get on with the discussion that these changes really do mirror what is happening currently in human rights protections, for example, in the province, and I would say across the country. So one of the most significant changes to the Occupational Health and Safety Act that will become enforced later this year is with respect to the definition of workplace harassment. What the changes will effectively do is expand the definition of workplace harassment to now include specifically workplace sexual harassment. And the definition you'll see on the slide mirrors very similar to the definition of sexual harassment for purposes of human rights legislation. And so there's two parts. It's either engaging in a course of vexatious comment or conduct against a worker in a workplace because of sex, sexual orientation, gender identity, or gender expression, where the course of comment or conduct is known or ought reasonably to be known to be unwelcome. Of course, that brings in the elements of the sex-based prohibited grounds in the Human Rights Code into this legislation. Of course, sexual harassment can also include B, making a sexual solicitation or advance where the person making the solicitation or advance is in a position to confer, grant, or deny a benefit or advancement to the worker, and the person knows or ought reasonably to know that the solicitation or advance is unwelcome. Again, this definition is very similar to the definition for purposes of human rights legislation. Okay. The other thing to note, and it's an important addition, certainly for employers, is that with these changes, there will be added to the Occupational Health and Safety Act a provision that makes express that a reasonable action taken by an employer or supervisor relating to the management and direction of workers or the workplace is not workplace harassment. So we typically get phone calls from our clients who will tell us that they're trying to manage an employee and it's just management in the course of either a performance improvement plan or just in the course of business, and yet they get resistance and complaints of harassment. The Occupational Health and Safety Act will now expressly say that that is not harassment. We've always known that to be the case, but now it's going to be codified in law, which I think is a welcome change for employers. So there are, of course, some very other significant changes that this bill will make to the Occupational Health and Safety Act in Ontario, and I want to review some of them with you today in more detail. The next slide has a very high-level summary of some of these provisions. So, of course, prior to this bill, there was a requirement that employers have a program in place and that the program have certain elements, including with respect to how employees could report incidents of harassment and what an employer was to do with respect to complaints. We now have something much more specific, and I want to just go through what some of those specifics are going to look like. So now you have to include in your program measures and procedures for workers to be able to report complaints where the complaint is against a manager or a supervisor. So you have to have an alternative way for that person to complain, so it's not to their manager or supervisor, which always made good sense, and certainly that was always our advice to clients, to make sure that you have an alternate route so that we're not sending somebody who's complaining about sexual harassment to the very person who's making that harassment. I think that just makes good sense and good practice. The program will have to specify how incidents and complaints will be investigated and dealt with. So how you will be investigating the complaints and how you will deal with them. Okay? You now have to set out how the information obtained about an incident or complaint of workplace harassment, including identifying information about any individuals involved, will not be disclosed unless the disclosure is necessary for purposes of investigating or taking corrective action. That's a pretty significant change. This is now mandating a level of confidentiality that in the detail of which was not in the legislation, not currently in the legislation prior to this bill. So that'll be a significant change. Of course, again, you might be doing this already. Certainly it's good practice. It's always been our advice to ensure that your investigation policies do deal with confidentiality with respect to people involved in the process. So now that's a legislative requirement. Another requirement will be to set out how a worker who has allegedly experienced workplace harassment and the alleged harasser, if that person is a worker of the employee, will be informed of the results of the investigation and of any corrective action that has been taken against the person who may be found guilty of the harassment. So that's obviously a change as well. And now is a codified requirement that you put in place some measure to be able to inform or process for informing the person who's complaining and the alleged harasser about the results of the investigation, but one step further, also about possibly disclosing corrective action. Now, it's unclear whether employers are going to be required to disclose what corrective action has been provided to or has been set out for the person who's found guilty of harassment, and certainly we've always taken the view that that's private information. So we don't tell somebody else, even if they've complained about harassment, about the specific nature of the corrective action. We can simply say, and we say that the person has been disciplined and the appropriate action has been taken, and not divulge anything further. It'll be interesting to see how this specific requirement plays out once it becomes enforced. So that is an interesting development, certainly, and we'll have to see how that plays out. Some other notable changes as a result of this bill. The employer will now have to ensure that the investigation is conducted into incidents of the workplace harassment that is appropriate in the circumstances. So that might be formal, that might be informal, that might be with respect to or getting an independent person to do the investigation. It has to be appropriate to the complaint. The worker who has allegedly experienced workplace harassment and the harasser, alleged harasser, if that person's a worker, are informed in writing of the results of the investigation and of any corrective action that's been taken as a result of the investigation. Okay, so that again goes back to that earlier point. And lastly, of course, you have to make sure, and this is a general theme that runs through the legislation, and certainly was no different than when the harassment and violence provisions came into place. You have to make sure you're reviewing your policy at least, or your program at least annually, or as often as necessary where changes are made. And of course, with that, you have an obligation as well to make sure your folks are trained on the program and the policy, including providing them a copy where appropriate of the program. So to keep in mind that these provisions that we're talking about this afternoon with respect to the changes to OSHA will be coming into force and applicable in September. So you have some time to ensure that your existing policies or practices are consistent with these new rules. One more thing I want to mention with respect to these changes is with respect to the power that the Ministry of Labor will now have to require an employer to order an impartial person who has experience, knowledge, and qualifications to conduct an investigation at the employer's consent. That is a new requirement, and obviously a very significant one. Again, it remains to be seen in what circumstances the Ministry of Labor an inspector will order an employer to do this, but certainly where they have the authority now to do it, and when they do, it'll be at the expense of the employer, which suggests to me that it's likely, the requirement here will likely be to hire externally from the employer, as opposed to hiring or requiring somebody impartial within a workplace to do an investigation. Okay, so we'll see how that one plays out. Obviously, we don't know yet, but we're all, I can tell you, we're all curious to see what the ministry will do with that provision. Of course, you may be already hiring external investigators where you deem it appropriate. What's different here, of course, is that you can be now mandated to do that at your expense. So just moving on to some other important changes in Ontario. Late last year, the government passed the Police Records Check Reform Act. The act is not yet enforced, but certainly, obviously, will become enforced one day in the near future and will have an impact on employers who do require checks either from candidates for employment or at any time during the employment relationship. So prior to this legislation, there was really no uniform practice or framework with respect to police records check. It really did vary depending on the location in which you were receiving your police record check. Either a local police department or the RCMP. It varied somewhat. So what that means is that if you're an employer sitting in Toronto and you get a police record check, you might have a chat or a police record that lists every charge, every encounter with police and so forth, whereas if you were somewhere east of Toronto or west of Toronto, you might get something that just set out the charges or convictions. So there's really never any consistency. With this legislation, we will certainly see that consistency. The legislation itself sets out a framework. And the bottom line really, and the important point for employers to know that once this legislation comes into effect, there will be limited information the employer will now receive. And that might be a good thing for some employers. Of course, our caution to employers is always with respect to how you use information. So if you don't have the information, you can't use it in a way that could be otherwise discriminatory in making employment decisions, whether that's at the stage of hiring or during employment. Two critical pieces here, and it's always been the case that you needed consent, of course. You can't just go and get a police record check on anybody. But of course, you need the prior written consent of the individual, and the individual can authorize the consent to be provided to a particular entity. In the case of employment, the employer. The employee also, or the individual, also has an opportunity to review what's on a record check. So that could be significant as well. Of course, in terms of setting policy for record checks, this legislation will require that employers look at their existing process for getting record checks and expectations with respect to record checks. If there's any client, if an employer has a specific client who has requirements that their employees who work on certain files have certain types of checks, they'll have to make sure that to the extent possible now under this legislation, they're able to provide that, or at least that they're following the right process to be able to get that information. Okay, I suspect that employers will also need to review any conditional offers of employment they make as well, so they're making sure that they ask for the appropriate information. So moving on, genetic discrimination. We've seen and heard a lot about this relatively recently, and some individuals with the onset of or the prevalence of genetic testing increasing, we're seeing, and I suspect we'll see a lot more of this, and a lot more issues arising for employers. Certainly, at this stage, we only have proposed legislation provincially. We've had some proposed legislation federally that really went nowhere. We've had the government promising to provide or set legislation with respect to genetic discrimination, and it just hasn't happened yet. So we're still very much at the early stages in terms of statutory change. But I think we're going to see a lot more of these issues come about. So this proposed bill would define genetic characteristics as genetic traits of an individual, including traits that may cause or increase the risk to develop a disorder or disease. And of course, it would prevent, the purpose of the legislation would prevent adverse decisions being made on the basis of genetic characteristics, whether that's with the view to preventing employers and insurance companies primarily from making decisions about someone's propensity to become ill given a genetic characteristic or not. That would prevent that discrimination. So that's still in bill form. The bill was presented earlier, I guess fall of last year. It's unlikely to go anywhere given that where we are in the year this year. But we'll see if anything comes of it for next year. Just one more comment before I move on genetic discrimination. Simply because there's no legislation currently that deals specifically with genetic discrimination, we would certainly take the view that it is likely, given the expansive definition of disability for purposes of human rights legislation, and certainly in Ontario and across the country, that you could be offside and likely offside human rights protections in the event that there is some discrimination based on genetic characteristics, and that would likely fall under disability for purposes of the Human Rights Code in Ontario. That prohibition on discrimination includes both for actual disabilities, but also perceived disabilities. So I just want to reference quickly smoking in the workplace. Of course, in Ontario and federally, there's legislation in place that prohibits smoking in a workplace. In Ontario, that workplace is defined also as a person's vehicle if they're using their vehicle as a workplace, so driving and for drivers and that sort of thing. We're also now dealing with e-cigarettes, which of course is very much in fashion at the moment. Now, this legislation has passed in Ontario, but it is not yet in force. It would very much, like the Smoke Free Ontario Act, prohibit the use of electronic cigarettes in enclosed workplaces, including a vehicle. So I'll move on to changes to the Employment Standards Act. Some of these changes came into effect some time back, so I'm not going to spend too much time discussing them. And of course, there's been some changes to the minimum wage and how minimum wage is set in Ontario. It's now done on a much more principled basis, so to speak. We also have requirements for posters and providing employees with their employment standards posters at the time of hire and posting them throughout the workplace. Of course, there's been changes to tips and gratuities in those industries where employees are partially paid by tips and gratuities, obviously to avoid employees not receiving their full entitlements to these amounts. And then we'll talk about the proposed leaves of absence that have been tabled. So the minimum wage now is tied to the Consumer Price Index, and it'll take effect every October 1st of each year, started last year. The Ministry of Labour will now announce and publish the new minimum wage before April 1. Of course, there are different minimum wages depending on categories of employment. That will not change. It'll fluctuate accordingly. The poster requirements came into effect spring of last year, basically requiring employers to provide individual copies of these posters and to post them in the workplace. There's also some changes to the enforcement tools. Of course, employers, the ministry rather, through the employment standards officers, may require an employer now to conduct an examination of the employer's records and practices to determine if an employer is compliant with the Act. Obviously, this was quite a significant change for employers, given that this power to require this review does not have to be resulting from a complaint made by an employee. It can be the ministry on their own accord requiring the employer to do these reviews and assessments. So we've been advising clients this is a good time before the ministry comes knocking to have a look at your practices and your records to ensure that what you're doing is compliant with the minimum standards. Of course, I addressed tips and gratuities briefly, but really these changes meant to prohibit employers from withholding tips and gratuities from employees. So critical proposed changes, at least at this point, because these are just proposed, would be the addition of 2 new leaves of absence in the Employment Standards Act. Of course, there's already several different types of statutory leaves available to qualifying employers and employees. These would be in addition to those. And they come by way of private member bills introduced earlier this year. One is Bill 175, and it's called Jonathan's Law. It's an employee leave of absence when a child dies. And the other is Domestic and Sexual Violence Workplace Leave Accommodation and Training Act, Bill 177. So we'll just review those briefly. So with respect to Bill 175, the proposed leave would be available for employees who have been employed with an employer for 6 consecutive months, and it would be in respect of the death of a child, a stepchild, or foster child who is under the age of 18 years old when the child has died. The employee would be entitled to 52 weeks of unpaid leave if the child dies for reasons other than related to a crime. And that exemption is made because, as we'll discuss in a moment or so, there is currently a statutory leave in respect of an employee whose child dies as a result of a crime. Of course, an employee, and this is common with other leaves, an employee who was charged with a crime in relation to the death of the child is prohibited from taking this, would be prohibited from taking this kind of leave. Bill 177 is proposing to include a leave of absence for an employee who needs to be absent due to domestic violence and the like. And it would be significantly, if passed, it would be a paid leave of absence of up to 10 days per calendar year if the employer or the employee's child experienced sexual or domestic violence. This, of course, is a departure from the leaves of absences currently in the legislation, certainly the one proposed under Bill 175. Those are all unpaid leaves. So if passed, this would require paid leave of up to 10 days per calendar year. And here are some additional details. The employee would be entitled to leave for the purposes of seeking medical attention for the physical or psychological injury caused by the violence, obtaining services from organizations such as victim services, domestic violence shelters, rape crisis, sexual assault centers, obtaining counseling, relocating for the purpose of making future violence less likely, seeking assistance from legal professionals or law enforcement, or doing anything else that's prescribed. Of course, there's nothing yet prescribed, but certainly the government could do that. As I mentioned, these leaves of absences are simply proposed at this stage. We'll see what happens, and of course, we'll keep clients appraised of all developments. So let's move on to the overview of statutory leaves of absence in Ontario. As I mentioned, currently in the legislation, there are no paid leaves of absences. Certainly employers who do provide some paid leave can overlap the paid leave with these unpaid leaves, but certainly for purposes of the minimum standards, that's not required to be paid. So we have currently pregnancy leave, parental leave, family medical leave, personal emergency leave, reservist leave, organ donor leave, critically ill child care leave, and crime-related child death or disappearance leave. So I won't go into too much detail with respect to these leaves. They're highly technical. Obviously, a pregnancy leave is an employee is eligible for pregnancy leave who is pregnant and who has been hired at least 13 weeks before a baby's due date. Maximum length of pregnancy leave, of course, is 17 weeks. It can be less. A parental leave for an individual who takes a pregnancy leave is 35 weeks, which then brings that individual's total entitlement for pregnancy and parental to 52. For all other individuals who are entitled to parental leave, which could include adoptive parents, that is 37 weeks. Family medical leave is unpaid, job-protected leave of up to 8 weeks in a 26-week period. And this is really meant to provide a leave of absence for an individual when a family member is terminally ill and there's a serious risk that that person may die in the 26-week period. In the slide, you'll see the family members for whom the leave may be taken, and that list is set out in the legislation. You'll see the last bullet is a relative of an employee who's dependent on the employee for care or assistance. That could virtually be anybody if that person is dependent on the employee for the care and assistance. Personal emergency leave. This would entitle an eligible employee for up to 10 unpaid days in a calendar year, not available for employees who are working in environments where there are fewer than 50 employees, but where where the workplace has 50 or more employees, this entitlement kicks in the day the person shows up to work for you, so the day of hire. They're entitled to the 10 days for that calendar year, and it's unpaid. And this is for personal illness, injury, or medical emergencies, death, illness, injury, or medical emergency, or urgent matter relating to a family member. So this would include bereavement, personal illness that's not planned, or medical emergencies that are not planned. I know it's, I would say, regular, commonplace for some employers to treat planned, say, doctor's visits as this type of leave, but technically that's not quite accurate, and it's really meant for those unplanned leaves that are required. So reservist leave was added to the legislation, I believe, in 2007. It's got very specific requirements, and it's not limited in time, and that obviously makes sense. It's not easy to impose a time limit on individuals who are taking reservist leave, given that the timing of their leave, the duration of their leave, is likely not known at the outset. Organ donor leave was added to the legislation in 2009, and it's for up to 13 weeks for the purpose of undergoing surgery to donate all or part of certain organs to a person, and it's a qualified person. Okay, and this leave, as most other leaves in the legislation, is not limited to a period of time in terms of the employee's employment with the employer, and is available to the employee from the outset of their employment. I'm mistaken, it's 13 weeks. It's like the pregnancy leave. Okay. And the organs are as well listed in the legislation, and it's also out there on the note. Critically ill child care leave can be taken to provide care or support to a critically ill child of the employee, and it can be taken for up to 37 weeks within a 52-week period. The employee is required to provide the employer with a certificate from a health practitioner stating that the child is critically ill and requires support, and to set up the periods that the child requires support. There are rules with respect to this documentation in the legislation, and when you do have an employee who's coming forward and asking for a certain type of leave, the employer is in the right to ask for documentation from a health practitioner to confirm the employee's need for the leave. So crime-related child death or disappearance leave, in the event of death, it would be 104 weeks of unpaid leave. In the event of disappearance, it's 52 weeks. And crime is defined as any offense under the Criminal Code of Canada. I wanted to mention just lastly, given that we're having a discussion about legislative changes, we are in the process now, the government is, I should say, of reviewing key statutes that govern employment in Ontario, including Labor Relations Act and the Employment Standards Act. And the government has mandated this review to be done because obviously the changing nature of the workplace and the different arrangements that are now in place, just to make sure our statutes are in line with these changes in the workplace. So we are in process, I should say, and we suspect that there will be recommendations for some pretty significant changes to other parts of the Employment Standards Act and the Labor Relations Act. So stay tuned for that. That's certainly on the horizon, and I know that employment law practitioners are waiting with bated breath to see what recommendations are accepted by the government and what ultimately becomes of those and how they translate into statutory change. So just a final word on statutory leaves of absence. Of course, statutory leaves of absence in Ontario and across the board really, there are protections set out in the legislation where an employee does or is eligible and does take a statutory leave of absence. And I've set out a list here, and these are general. Obviously, there's some exceptions, but the general rule and the most important one is this right of reinstatement and to be free from penalty. Of course, you can't punish an employee from who has taken a a leave to which they're entitled to under the legislation. Where that most often comes up, and I believe we'll be talking about it, we'll be addressing it to some extent later in the presentation, is with managing attendance, of course, because those days add up, whether they're statutory or not, and they have an impact on your workplace. You have to be very careful with how you roll out attendance management programs to avoid penalizing employees, or at least to be seen to be penalizing employees who are taking a statutory leave. Okay. There are some rules with respect to the rights that continue with respect to participating in group benefits, pension plans and so forth, and there's some exceptions. And of course, there's the right to continuity of service and seniority, and to count all periods of leave to an employee's total length of service for calculating and determining rights under the legislation. Those are the fundamental ones. So with that, I think my portion is done, and I'll pass it over to Stacy and Kathryn. Thank you.
Great. Thank you so much, Laura. That was really informative. And now Stacy and I are going to review human resources tips for managing leaves of absence, which can be one of the more challenging aspects of HR management. So the first type of medical leave that we'll offer HR tips on is, as Laura mentioned, was the family medical leave. And just a note that outside of Ontario, it can be known as compassionate care leave. And this leave, keep in mind that all full-time, part-time, or contract employees who are covered, for example, by the Ontario Employment Standards Act can take the leave. And as Laura mentioned, to qualify, the employee must need to care for a specific family member. But this is also important, and Laura did highlight it. It can also be someone the employee considers to be like family, who they're taking care of, who's at risk of dying in a specified time period. So that's important to highlight again. And from a management perspective, the employee must provide a certificate from a qualified doctor to the employer indicating that the family member is at risk of passing away in the next 26 weeks, which, on a side note, distinguishes it from family caregiver leave. And because of the nature of family medical leave, keep in mind that the certificate doesn't have to be issued before the leave is taken. It can be provided within a reasonable time frame after the leave has begun. Also, it's the employee's responsibility to obtain the certificate and to pay for any fees associated with getting the certificate that many doctors charge. But as an employer, you can choose to cover this cost for the employee, and we find that most employers do cover the cost. And finally, again, to recap quickly, the leave entitlement is up to 8 unpaid weeks in a 26-week period. Keep in mind as well that the leave doesn't have to be taken consecutively, and if illness continues, the employee can reapply for more time. Also, the 8 weeks can be shared with others. So, for example, if you take 6 weeks of the leave, your spouse can take another 2 weeks either at the same time as you or separately. Another management point is that the employee is required to provide written notice of their desire to take the leave, but again, it doesn't have to be in advance of taking the leave, just like the medical certificate. If written notice is not provided, it doesn't take away their right to the leave. It's simply a courtesy to the employer, and I think you'll find that most employees will provide the written notice upon request, and provided a reasonable amount of time is given to them to get the information to you. Always keep in mind as a manager or HR practitioner the stress the employee is probably under, and work with that employee accordingly when they're trying to get the information for you to back up the leave. Since the leave is unpaid, the employee can apply for government employment insurance benefits called compassionate care benefits while they're on leave. So you can assist them with that as well. And now I'll turn it over to Stacy to discuss personal emergency leave from a management perspective.
Thanks, Kathryn. So we often hear clients and employees confusing Ontario's personal emergency leave with the family medical leave. In fact, they're really two totally separate leaves. And unlike family medical leave, which we just discussed, personal emergency leave is unpaid job-protected leave up to 10 days, which Laura already mentioned. And it includes employees that we talked about will even start halfway through the year. So personal emergency leave can be taken for personal illness or injury or an urgent matter relating to themselves or certain family members. And it's important to remember that the employer must count all employees across Canada and internationally. So when we say you must employ 50 employees or more for this to qualify, it does include all those employees across any employees that you have. It doesn't just mean those Ontario employees. And it also does include those part-time employees. They count as full-time employees in this regard as well. So also the list of people for whom a family medical leave can be taken is not identical to the list as Laura had on her slides. The list is more restrictive for the personal emergency leave. And also an employee can use this leave for pre-scheduled surgeries as long as the surgery is not cosmetic and is actually to treat an illness or injury. So we often get asked if an employee is entitled to the leave even if the injury was caused by carelessness, such as the employee trying to barefoot water ski at the cottage on the weekend. And the answer is yes, they would be entitled to that leave if all other qualifiers exist. So be aware that an employee who qualifies for both leaves would have full entitlement to each leave and to the protections that we discussed earlier. So before we move on from personal emergency leave, I wanted to review the definition of urgent matter a bit more, since this is sort of vague in the language in the Act, and that seems to get under a lot of employers' skin the most when they talk about it being an urgent matter. So an urgent matter is an event that is unplanned or out of the employee's control and raises the possibility of serious negative consequences, including emotional harm if it's not responded to. So some examples of an urgent matter that qualify for this leave would be the employee's babysitter calls in sick, or the house of the employee's elderly parent is broken into and the parent is very upset and needs the employee's help to deal with the situation, or the employee has an appointment to meet with his or her child's counselor to discuss behavioral problems at school and the appointment could not be scheduled outside of the employee's working hours. Examples of events that do not qualify as an urgent matter would be something like the employee wanting to leave work early to watch their daughter's track meet, or the employee wants the day off in order to attend their sister's wedding as a bridesmaid. So lastly, another common question, Lastly, another common question we receive is how to integrate your employer's sick day policies with the personal emergency leave. The rule is that if an employment contract provides a greater benefit or right than the personal emergency leave standard, then the terms of the contract apply. However, if the contract does not provide a greater right or benefit than the personal emergency leave standard in the ESA, the personal emergency leave provisions of the ESA will apply to that employee. So it's important to understand that the Ministry of Labour will not get involved in determining how the leave provisions of the contract are applied. So for example, if an employee's family member passes away and you provide 3 paid sick days and 3 paid bereavement days to your employee, the employee can use up all 6 of those paid days and still be entitled to the 4 unpaid days under the personal emergency leave provision. If the employee argues they should get the 6 paid days plus another 10 emergency days, personal emergency days, then it's up to you to determine your internal policy. And the ministry will not comment on what the employer should do. So just be sure that your internal policy is consistent across your company. And now I'm going to turn things back over to Kathryn to start our final topic, disability leaves.
Thanks. So first we're going to review short-term disability leave. So 2 scenarios are commonly played out when an employee is suffering from an illness or injury that will extend longer than taking a few days off. In both scenarios, the employee has been away from work due to illness. However, in the first scenario, the employee will come directly to you and request an extended leave of absence to care for their illness. In the second scenario, the employee keeps calling in sick but never approaches you on how long they will keep doing so. In both cases, your first step is to review the current policies you have in place. For example, what is your paid sick day policy? Has the employee exhausted all of those days? Some employees may choose to use paid vacation days once their paid sick days are used up, but be cautious not to force them to use their vacation time. Next, review your group benefit plan if you have one. Does it offer short-term or STD insurance to the employee? Normally, STD will kick in after the employee is considered totally disabled, meaning that the employee has a medically diagnosed condition which renders them unable to be actively at work. If no accident or hospitalization is required, there is normally an approximate 8-day waiting period to receive the STD benefits. If an accident or hospitalization has happened, STD should kick in right away. You can certainly combine your sick day policy and vacation or PTO policy to cover the employee with paid time off until their STD or again their short-term disability kicks in. Work with the employee so they understand the process and all forms that need to be completed. Your next step would be to request a doctor's note to confirm the employee is unable to work. Request an estimated return date, and if any accommodations are required, be sure to provide a job description for your employee to show their doctor. Provide the employee with a medical request form to get specific information from that doctor. That way you won't just get general information back. Medical documentation is important to back up employees on sick leave, as well as to indicate if they are well enough to return to work and under what conditions, meaning do any accommodations apply. When dealing with short-term disability, be careful here not to be too clinical with the employee. Be sure to be empathetic and understanding of their disability. It's very easy and common to think that an employee is trying to trick you or take advantage of the system, maybe to get time off, maybe to escape progressive discipline, or from being terminated due to poor performance. Be sure as a professional to catch yourself and rise above the distrust and work professionally with the employee. By keeping open communication with the employee and remaining on good terms, you'll have an easier time getting the information you need so you can plan your next steps. You can't force an employee out on leave, so by working with them, you can try asking the employee what they would like to see happen. You can provide some options, such as taking a sick leave. By working patiently with the employee and providing options, if you run into any disputes down the line, you can show you are acting in good faith. Your next step would be to provide all the proper application forms to the insurer, and this is assuming you have STD insurance through your benefit carrier, as soon as possible. There's no need to wait. With your help, the employee will have to ensure that 3 forms are submitted to your insurance carrier. There's an employee statement, the attending physician statement, and the employer statement, which should be completed by you. Keep in mind that the employee is not obligated to share any confidential medical information with you. The employee should submit their completed employee statement and attending physician statement directly to the insurance carrier. You can submit the completed employer statement section separately. Often, the ill employee is not able to keep up with the insurer deadlines either. We see this all the time. So keep in touch regularly with the employee and remind them of the deadlines to get their paperwork in. They'll find this really helpful, and it'll help your process as well. So now, if you don't have a short-term disability policy through your group benefit plan, and it's determined that the employee agrees sick leave is the best option, here you'd issue the employee's record of employment, the ROE, via Service Canada, so the employee can apply for employment insurance while on their short-term disability leave. The employee will have had to have worked 600 hours in the last year, again this depends on location, to be eligible, and they will have a 2-week waiting period prior to EI benefits kicking in. Important to keep in mind here is that any paid time you offer, such as sick or vacation days, will be clawed back from the employee's employment insurance benefits. So think about that when you're planning how to roll this out. EI benefits will be limited to a maximum of 15 weeks and to 55% of the employee's income to a maximum amount of $537 per week. Again, make sure to be open and share as much information as you can with the employee. Employees can apply for sick leave benefits online with Service Canada. I suggest providing them the link and doing your best to help your employee through what might seem to them like a very daunting process. Some employees might even be embarrassed about having to collect employment insurance. Reassure them that the sick leave benefits are a normal part of the EI program. Your efforts to alleviate any fears or concerns will serve you and the employee well in the long run. And then step 5 is to remain in contact with the employee. Remember to keep the employee's group benefits active while they are on leave. They must continue to pay their portion of the premium, so stay in touch regarding getting post-dated checks, etc. Ensure the employee has all the information they need. So for example, group benefit information if that applies, their record of employment, the Service Canada links like I mentioned. And be cautious of distrusting the employee and using over-the-top surveillance. So please don't hire a private investigator to follow them around to see if they're truly ill. That is just not going to turn out well for you. And remember to obtain a clearance from the employee's doctor when they're ready to return to work, and to implement any accommodations required and backed by the doctor's certificate. And again, it's helpful to have the doctor complete a medical request form and to pay for those fees that the doctors will charge on behalf of the employee. And now I'll turn it over to Stacy to complete this section by discussing long-term disability leaves.
Great. So what if an employee cannot return from short-term disability and they do go on long-term disability? Well, without coverage through a group benefit plan, you would have to work with the employee on seeking provincial help to cover their expenses. And if you do have a group plan to qualify for LTD coverage, the employee must usually have worked about 119 days of total they usually have to have about 119 days of total disability. So keep in mind that some insurance carriers will allow the employee to do trial work during that period to see if they're healthy enough to go back to work without affecting their elimination period, which is the 119 days before the LTD kicks in. So the trial work period can be reduced to schedule and or modified work. It's important to note that the LTD benefits are non-taxable if the employee has paid their portion of the LTD premiums. If the employer has paid the LTD premiums, the LTD benefit is taxable to the employee. So when setting up your benefit plans, be aware and explain to employees that if they pay for their own LTD premiums plus the sales tax on those LTD premiums, it protects them from taxation down the road should they unfortunately ever have to collect. So most LTD coverage will continue on most plans to the age of 65. So you'll also want to remember that you're entitled to know if employees have claimed LTD benefits, along with certain basic information such as the status of their claim, the employee's ability to perform their own occupation or modified work, and their estimated return to work. You can work with your insurance carrier to answer any questions, but we strongly recommend that you use your own medical request form to get information from the employee's doctor. Don't rely on the insurance carrier to share all their information with you, and you must collect any requests for accommodation directly from the employee's doctor. You're also going to want to check if you have a statement in your employee agreement stating when health and dental benefits will be terminated if an employee is on LTD. So if you have nothing with regard in your contracts in regards to this, you're likely going to have difficult time terminating health and dental benefits, even if your employee has not worked in a long time and may not return for a long time. We worked with a client whose employee was on LTD for 6 years before the client company restructured the employee's job, and it was eliminated, and they were then able to terminate her, even with a generous termination package, before they could terminate her health and dental benefits. They were paying her premiums, and she was paying her portion of the premiums for all those years. So to have terminated her health and dental benefits would have been discriminatory since under the Human Rights Code. So her job was still open to her while she was on protected leave. So frustration of contract to determine when your employee should be terminated and thus terminated from your health and dental plan is worth a call to your lawyer. Also, always remember that the employee on medical leave is probably very ill and is relying on the prescription coverage in your group benefit plan, for example. So in the case I just referenced, we helped the employee tap into a provincial plan and connected her to an individual plan, and our client paid out her lump sum to assist with those individual plan premiums with her termination package. So it's not easy to manage medical leaves of absence, but if you take anything away from today, it's to work closely with the employee and provide as much information as you can on options. We find this is the key to avoiding discrimination lawsuits or other unnecessary liability. And now Kathryn's going to finish up today's webinar with some closing comments.
So as Stacy and I have both mentioned today, managing leaves of absence can be one of the more complex aspects for employers. When employees' leave request is not straightforward, it's key to know when to reach out for help. Hopefully today's webinar gives you options of trusted advisors. Laura Cassiani of Miller Thomson, who has successfully helped HR options with legal issues in the past, or a trained advisor, HR consultant such as HR options is another option. It's important for the protection of your company and the dignity of the individual on leave to ensure you're taking the correct actions in any leave situation. During today's introduction, I'm just going to throw it back to what Ninju had mentioned a little bit at the beginning about HR options, that we not only provide on-call HR support, but we also provide employee and management trainings, policy development, etc., as well as a unique service called outsourced employment, where HR option acts as the employer of record for employees, meaning that we handle all employer administration for you, including payroll, tax remittance, insurance coverage, group benefits, and human resources support from the beginning of employment to the end of the relationship, including leave management. This is just yet another option for any listeners today who may not have the experience or resources to employ and manage HR confidently across Canada and across the different provinces. So please contact HR Options for more info. We'd love to hear from you. So that wraps up the webinar today. what I'm going to do now is turn it over to Nunzio for the question and answer section. And if we don't have time to get to your questions, we'll definitely reach out to you directly after the webinar, and feel free to reach out to any of us directly as well.
Thank you, Kathryn, Laura, and Stacy, for all that information. It was truly great, and I personally enjoyed it. Let's jump into some questions now that have come in throughout the presentation. First question is for Laura. What are the most significant changes for employers when it comes to investigating workplace sexual harassment and violence?
Well, that's a great question. I think certainly, in my opinion, these changes that are now going to become effective in September for employers really codify the best practices. So to the extent that you need to review your policies, you should, but to answer your specific question, I think the important ones would be, one, the Ministry of Labor now having this ability to order the employer to hire or engage an impartial investigator, which of course we interpret to mean an external investigator at your cost. I think that's quite significant. The other two things are, and again, it really ties into best practices, but now more formally legislated, is this requirement to provide something formal in writing, which I believe makes it more formal, of course, with respect to the results of an investigation to the parties involved, the complainant and the respondent, and to advise of this corrective action that is taken or will be taken with respect to the incident, which could arguably include other changes the employer would make would make as a result of the investigation, including possibly retraining or changing a policy or practice. So I think those are the significant ones for sure.
Thank you, Laura. Next question is for Stacy. If an employee doesn't show up for work for 1 week without contacting the employer, is their job protected under personal emergency leave?
Right. Well, again, it's really a case-specific situation in a matter like that, but I would say that if the employee hasn't contacted you about this emergency, that the time that they've been off, that it's important to reach back into your policies to find out what you do if an employee doesn't show up to work. I mean, that's reaching out to the employee, contacting them, trying to get a hold of them. If you aren't able to do that, possibly sending a registered letter to confirm that you need to hear from them within 24 hours, sort of exhausting all your options to find out where and how this employee is or what they're doing or what's happening with that employee. And, of course, if they come back and they explain the situation, then it would be, of course, if it was emergency for those 5 days, it would be qualified under the leave.
Thanks, Stacy. Next question is for Kathryn. Will all the pending changes to the employment legislation discussed in this webinar apply to all employers regardless of size?
I'll let Laura jump in on that one in a second too, but I think our advice is always to check the legislation specifically to see what the parameters are, and if it does have like a under 50 or over 20 employee size. And then also, I think Stacy had mentioned in one of her sections, always be careful when it says you have to have 50 employees to actually dig down and see what that 50 employees means, because sometimes it doesn't just mean 50 employees in Ontario; it can mean 50 employees all across Canada and internationally. So I would check that, and I'll let Laura jump in to give her answer as well.
Yeah, I mean, I think that's exactly right. I think these changes will vary. It depends on the number of things, including size of the employer, but also other eligibility requirements. You always want to check to make sure that whatever's scheduled to be enforced is something that applies to you, and if it does, then obviously to take the appropriate action.
Perfect. Thanks, Laura. We'll jump back to you, Laura, for the next question. Will you need consent to obtain a police record check from your employees?
Yes, and the general rule will be that you'll need the prior written consent of the employee. Now, that's a technical requirement. That doesn't begin to address whether an employer can or cannot ask for a police record check. with respect to employees mid-employment, right? We talk a lot about, imposing a requirement like that when someone's already started employment, when at the time of hire it certainly wasn't a requirement that they provide some ongoing update about their, criminal status or background check. We tell clients, of course, that the best advice is to make sure that at the time of hire, certainly if it's, if the offer is conditional upon getting the check, that you get it with the employee's consent or the candidate's consent, and possibly having the candidate go and get the record that's brought back to the employee, put that obligation back on them, and then during employment, possibly the same thing, but making sure that you have a policy or something in writing that the employee is aware of at the outset, that they could be required to provide updates on their criminal background check, right? Because if you don't, then you possibly could have an issue with imposing that requirement down the road.
Perfect. Thanks, Laura. So we have time for one more question, but I also want to ask all the participants to please take a minute to complete our evaluation by clicking on the survey widget at the bottom of your screen. So our last question is for Stacy. If we don't have an employment contract and the employee goes on long-term disability, when can we remove the employee from our health and dental benefit plan?
And yeah, that was another thing that was brought up during the presentation, but it really depends on, again, specific scenarios. You don't have a contract in place for that employee, I think you mentioned, then you really have to go by when there's probably a frustration of the agreement or a frustration of employment. So you definitely want to look at all the factors, and in a case like that, you probably want to get in touch with your lawyer or attorney in a case like that.
Okay, perfect, Stacy. Well, thanks again, everyone. So we're out of time for today. And again, I would like to personally thank the panelists for all this information that you provided throughout the webcast. It was truly amazing. And also, please view their contact information on the last slide. I do look forward to seeing you all online at future webinars, and I hope you all have a great day. Thanks, everyone. Bye.